Okay, thank you.
Is there any likelihood I can sit down in person with my clients and they work out something?
I would say we can certainly try to set something up. You know, I know that, you know, was it with today's virtual world? And I have a lot of hearings and other things, I'm sure you do, but we can try to communicate. So did you receive my email, sir?
No, I just want to be sure I got my answer. I haven't been back to my office till tomorrow.
Okay.
I'm sure it's there.
So I sent you an email. What I will do is, I will speak with my client and then I will reach out to you at the beginning of next week to see if we can then try to put that together.
You think there's a chance that will buy back that trailer? With my clients, they don't want to go back there again. They're just looking to the hole.
I mean, I can talk to my client about what, I know we're being recorded, so I don't want to share everything, of course, but I will talk to my client in regards to what they are open to. So when we have our formal meeting, we can discuss those things. In the meantime, as I stated, we'll, you know, formally move forward with this current case. But like I said, when you get back to your office, my contact information's there. What is a good day next week to reach out to you?
Is there another number besides your office number I can call you about? Is there another number besides your office number I can call? You have a personal cell phone.
Yeah, it's in the email I sent you.
Okay, the person, not the 909 number.
No, it's a different number. It's on the email that I sent you.
Okay.
That's better. Okay. This is 220945 LT. This is Rawsonville Woods versus Sierra Curtis and Barbari Simpson. May I have your appearances, please?
For the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of Rawsonville Woods.
James Walker, on behalf of the defense.
There are like 8 people here, so if you want to look, you can. Are they in the wrong place? I think I see your client, Mr. Walker Dean. That's why I'm hesitating. The parties had a brief conversation before court began this morning regarding the status of this matter. The court has received the answer to the complaint filed on behalf of the defendants. Mr. Morton, how are we proceeding this morning?
Your Honor, at this time, was it my office intends to file a response to the counterclaim that was also included in the answer? I think it's best to set this matter out. I think it would say initially, 30 days to allow the answer to be filed. Mr. Walker Dean and I are going to try to have a meeting as well in the meantime. That way my client can file a formal answer in this. I can file a formal answer in this matter. And potentially I will tell the court that depending on the result of our resolution, we may end up also seeking a motion for summary. But I want to be able to have a good sit down with Mr. Walker Dean first on this matter.
Perfect.
Okay, 30 days discovery in this matter. We're going to adjourn the pretrial to May 3rd, 2022 at 2 p.m.
Perfect.
Back on Zoom, or on Zoom. If you want to come in person, that's fine, Mr. Walker Dean, but Mr. Morton, how long do you need to file your answer, your response?
I expect to, I don't want to limit myself too much, but I can probably, I don't see an issue with me getting it in by next Friday.
I'll say 14 days.
Thank you.
Civil Department will send out notice. Anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. Walker Dean? Have a good afternoon, sir. Good to see you. Yeah, because I don't use it. Thank you, sir. So when they check in, you just give them to Mary Ann, and Mary Ann can give them the Zoom ID and get them back here. Thanks.
The ones that you had in front of you, were those okay? Because I know you had like 3 of them right there in front of you. Were those, can I check those or?
They were there because the people were here.
Oh, okay. Good.
Okay, thanks.
Thank you.
This is 220667 LT. This is Metro Commons versus Holland.
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
State your name, please.
Horace Holler.
Mr. Holland, thank you. Ms. Scheid, before you appeared, I had a brief conversation with Mr. Holland, and he has applied for SARA funding. His SARA number is 403205. Based upon his filing for financial assistance, this court is required to stay these proceedings. Mr. Holland, what that means is that the next step is that you will receive a notice from the court indicating that the matter has been stayed. As long as plaintiff does not receive notice within the next 45 days that you are ineligible for assistance, the matter won't come back before this court. If for some reason within that 45 days, your SARA application has not been ruled upon, or you've not been deemed ineligible, or if you've been deemed ineligible, the plaintiff's attorney may file a request with this court to lift that stay and reschedule the matter for hearing. Understood?
Yes, ma'am.
Anything else, Ms. Scheid?
No, Your Honor.
Anything else, Mr. Holland?
Yes, Your Honor. I was already approved a month and a half ago. They already sent out my utilities. I had called her yesterday. She said the check was sent out on the 16th. It was cleared on the 22nd. So they should be getting it between this week and next week for sure.
When they receive it, then they're likely to dismiss the case unless there's some amount that you owe. And if you owe a portion, I'm sure somebody will be in contact with you as to what that amount is.
Yes, Your Honor.
Anything else, Mr. Holland?
No, Your Honor.
Have a wonderful day, sir. Thank you.
Thank you.
This is 214422 LT. This is Park Estates versus Daphne Rice and William Wells.
Jenny
Yes,
Scheid
ma'am.
on behalf of the plaintiff.
Yes,
State your
please,
name.
Daphne Rice, please forgive the noise behind me now. Your Honor.
I couldn't hear what you said, ma'am.
No, I'm at work, so there's a lot of noise behind me. This is the only area that I can go and talk to.
Ma'am, are we expecting William Wells this morning?
No, ma'am.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now for 147 days. How are we proceeding in this matter?
So I'm just now going back to work, and I had to work a week in a hole. So what had happened, they end up not paying me my full check, but I have $1,000 that I could pay. I went yesterday to try to pay it, but no one was in the office. So if I can drop it off somewhere or just stick it in the door, I could pay the 1,000. But if I can pay I think the balance will be $174. And if I can pay that, that's not the balance?
Not quite, because there's also court costs. So your rent to retain is $1,183.52. But there's court costs of $170.06, bringing the total to $1,353.52. If you think you can get this paid off by the 11th, we can enter a consent judgment on the record
Yeah.
that
Wait,
would
ma'am,
allow you to.
I'm sorry, would you give me those numbers again, please?
Sure. Rent to retain is $1,183.52. Court costs of $170.06 for a total of $1,353.52.
And Ms. Rice indicates she has $1,000 right now. And Ms. Rice, how
Right.
long do you need to pay the balance?
Well, she's giving me to the 11th, that'd be perfect. But I would have the other 178, because I forgot to add the court costs. So you should forgive me for that.
Well,
But
the other thing I'd like to mention though too is that your April rent is going to come due on Friday.
You know
Yeah,
what,
that's-
let's do this. Let's move you into a breakout room and you can discuss that matter.
Okay.
Okay.
Do I stay? Oh, okay. Do I stay online?
You know who's a courtroom you're in? Judge Lisa Martin, courtroom 4. Yes, okay.
Ms. Reed,
Yes, ma'am.
thank you. The attorney for your apartment complex is in a breakout room right now. Have you applied for financial assistance through the Sarah program?
Yes, ma'am, I have.
What's your Sarah ID number?
489997.
When the attorney comes out, we will relay that information to them, okay?
Yes, ma'am.
Thank you. Sit tight.
Thank you.
Mr. Morton,
Yes, Your Honor.
do you see one of your tenants?
I mean, I don't know who the Galaxy S20 is,
I'm
of course.
trying.
Yeah, I'm looking.
Good morning, Mr. Herman.
Morning, Judge. How are you?
I am wonderful, sir. How are you?
I'm well, thanks.
Your Honor, I believe Miss Hall is with one of my cases. I believe she's here for Miss Loretta White. That's the other one that might be contested with me. But if you want to put Miss Hall and myself in a breakout room, I think I have admin control. I might be able to do it, but if you want to do it, or I can do it, Your Honor.
You have your permissions, and we'll get Miss Hall into the space with you.
Thank you. I moved you.
Ms. Scheid, are we ready with Ms. Rice?
We are, Your Honor.
How are we proceeding in this matter?
We are still going to enter to a consent judgment. She is going to pay $1,000 this week. Then she will pay the remaining $353.52 plus her April rent by April 15th. We're going to give her a few extra days based upon her paychecks.
Ms. Rice, were you able to hear Ms. Scheid just now?
Yes, ma'am.
And ma'am, is your understanding and agreement that you owe a total of $1,353.52?
Yes, ma'am.
And that you will pay $1,000 this week. This week will put us on April 1st.
Yes, ma'am.
And then $253.52 plus April's rent by April the 15th.
Yes, ma'am.
And this will be done in the consent judgment.
Yes, ma'am.
Because the
Your Honor,
parties
I
are
did not
virtual, have you
advise
authorized
Ms.
Oh, I'm
Rice of
sorry.
her rights under the fact that we're going to be doing a consent judgment with her not being represented. She is entitled to have, to be advised that she would be able to submit a request to have that set aside within 3 business days upon good cause shown to yourself.
Okay, yes.
And ma'am, that is what you wish to agree to?
Yes, ma'am.
I've written that in file. Plaintiff's office will submit the consent judgment to the court for signature, okay?
Yes, ma'am.
Anything else in this matter on behalf of the plaintiff?
No, Your Honor.
Anything else, Ms. Rice?
No, ma'am.
We are all set, ma'am. You can log off. Have a good day at work.
Thank you. Yes, ma'am. You too.
Thank you.
Bye-bye.
This is 220719 LT West Village Estates versus Latanya Reed.
Jenny Scheid on behalf of the plaintiff.
Ms. Reed, state your name for the court, please.
Latanya Reed.
Thank you. Ms. Reed has applied for Sarah funding. Her Sarah application is 489997. Ms. Reed, based on your submission of the application for financial assistance, this court is required to stay these proceedings. You'll receive a notice from the court indicating that the matter has been stayed. Within 45 days, plaintiff should have received either notice of your approval or payment from the Sarah funder. If they have not, they may file a request to this court to lift the stay and reschedule the matter for hearing. Understood?
Yes, ma'am.
Anything else on behalf of plaintiff?
Your Honor, can you repeat the number for Sarah again, the 6-digit number?
489-997.
Thank you, Your Honor. Nothing further.
Thank you. Ms. Reed, have a good day, ma'am.
Thank you, ma'am.
Tyrese Haskins.
Sorry, Richard Herman on behalf of the plaintiff.
I had the 220920 LT Southport Apartments versus Tyrese Haskins.
Good morning.
Thank you. Today is the day and time set for the second hearing in this matter. Parties first appeared on March 23rd, 2022. Mr. Herman, how are you proceeding this morning?
This is a go forward, Judge. I have no information on this matter relative to Sarah or anything. So perhaps if I can ask Mr. Haskins, I'm sorry.
Yes,
Mr. Haskins, have you made an application for financial assistance through the Sarah program?
Yes, ma'am.
Your
My
Sarah number, please.
603770.
No.
Would you give that number again, sir?
603770.
That's better. Thank you. When did,
Based
when,
on, I'm sorry, go ahead, Mr. Herman.
I was just wondering, Mr. Haskins, when did you apply for that?
That would be Friday. I received a notification that Southport was informed on Monday.
Okay, perfect. Thanks.
Mr. Haskins, based on your application for financial assistance through the Sarah program, this court is required to stay these proceedings. The next thing you'll receive from the court is a notice of that stay. It'll indicate that within 45 days, plaintiff will have received payment or some indication that you are ineligible for financial assistance. If that 45 days comes and plaintiff has not received either of those two things, they may file a request with the court to lift the stay and reschedule the matter for hearing. Understood?
Yes, ma'am.
Anything else, Mr. Herman?
No, I just wanted to let you know, Mr. Haskins, the total amount you owe to get you through March is $1,075. Don't forget that in a few days, like maybe tomorrow, April's rent is due. So when you're dealing with Sarah, just let them know that, please.
Thank you. Will I receive some notice from the court in regards to the 45-day stay and anything moving forward?
I just said that, sir. The next thing you'll receive from the court is a notice of entry of that stay.
Thank you.
Anything else, Mr. Haskins?
No, ma'am.
Have a wonderful day, sir. We're all set.
Thank you. You too.
Good luck, sir.
There's a
Thank you.
person on a phone that I'm trying to get identified. Oh, Mr. Herman, your dog is so cute.
Thanks. Thank you.
I threatened to bring my dog to work, but I don't think she would stay awake more than 15 minutes.
How old?
Almost 11.
Yeah, I have two of these. I don't know which one you just saw, but one of them's 14. So I know I feel that pain, Judge.
I thought I just saw a black tail go by.
Yeah, you did. There's two black tails somewhere in this house.
Good morning, Mr. Bigham.
Good morning.
Have you filed for financial assistance with the Sarah program?
Yeah, they know all this information. The rent office know all of it.
Mr. Bigham,
Yeah.
your
Can you hear me?
6-digit Sarah number for me, please, sir.
556273.
The attorney for your complex is in the breakout room. Sit tight when he comes out. We'll get that information to him and get you on your way, okay?
All righty.
Thank you.
Dad already knew the information. I've been in contact with the rent office.
Sir,
Yeah.
it's not about them, it's about me. I don't have it. It's not in our court file.
Oh, okay. I apologize. Sorry.
No, don't apologize. I just want us to be on the same page. Now I'll have it and then
Okay.
we'll handle your matter.
Okay, thank you.
You're welcome. I still don't know who this is. Two 20715 LT West Village Estates versus Richard Dezen.
Good morning again, Your Honor. Jenny Scheid on behalf of the plaintiff.
Ma'am, today is the day and time set for the second hearing in this matter. Defendant failed to appear for the first hearing on March 23rd, 2022. Clerk sent notice to appear in person today. No one is responding to the name Richard Dezen. The matter was scheduled at 9 o'clock, is now 9:19 by this court's clock. Defendant having failed to appear, how do you wish to proceed?
We are requesting a default judgment be entered against Mr. Dessen for failing to appear at both hearings. There is rent to retain of $1,325.50, court costs of $164.50 for a total of $1,490. This would be for him to pay or vacate by April 11th, 2022, and this is for possession only.
Rent to retain $1,325.50, cost of $164.50.
Yes,
That total's not right then. Maybe my math is off.
oh, my apologies. Let me pull up my calculator. Okay, 1325.50 plus 164.50 equals 1490, Your Honor.
All judgment will enter in favor of plaintiff and against defendant. Rent to retain $1,325.50, court cost of $164.50 for a total of $1,490. Anything else in this matter, ma'am?
No, Your Honor.
Thank you. Are we ready with Ms. Hall?
Yes, Your Honor.
Can't hear anybody. I can't hear nobody.
Ms. Hall?
Hello?
Yes, ma'am.
Can you hear me?
Yes, ma'am.
I can't hear anybody. God bless.
What's that file number, Mr. Morton?
It
I thought
is
I saw it.
22-0932 22-0932 LT. It's listed under
Thank
Loretto
you.
Wright.
Ms. Hall?
Yeah, it appeared.
I can't hear anything.
Ms. Hall? Okay.
Yeah, Ms. Hall was
That for a
Ms. Hall was
second.
able to hear me in the breakout room. I'm not sure what's occurred, Your Honor.
Well, let's try something different. 220934 LT Rawsonville Woods versus Jerry Bigham.
Oh, Mr. Biggs, okay.
He's here, he's downstairs, and he's indicated to the court that he has made an application for Sarah funding.
Understood, Your Honor.
Nothing, can I hear?
Mr. Bigham, state your name for the court, please.
Jerry Bigham. It's actually been approved. We got approved on the 1st of March. So they just waiting to receive payment. I don't know, it said take 3 to 4 to 6 weeks or something.
Mr. Morton, that number is 556273. Sir, based on your application for Sarah funding, this court is required to stay these proceedings. The next step is that you will receive a notice of that stay from the court, which indicates that plaintiff is to receive payment of what's due within 45 days or some indication that you're ineligible for Sarah funding. If we get to that 45-day mark and neither of these things has happened, plaintiff may file a request to the court to lift the stay and reschedule the matter for hearing. Anything else, Mr. Morton?
No, Your Honor, just as long as Mr. Bingham knows. Mr. Bingham, the big thing is the Sarah payment gets distributed. This case is done then. If it doesn't, then my client can then request a new hearing date. Does that make sense?
It makes sense. Thank you. Appreciate everything.
Absolutely.
Anything else, sir? Mr. Bingham, anything else?
No,
Have a good day, sir.
y'all do the same. Thank you.
Thank you. This is 220721 LT. This is West Village Estates versus Daniel Oliver.
Morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Good morning, sir. Your name, please. Your name, sir?
James Young Jr.
Thank you. Ms. Scheid, this matter was scheduled at 9 o'clock. It's now 9:25 by the court's clock. Daniel Oliver failed to appear this morning. How do you wish to proceed?
We are requesting a default judgment for failing to appear at today's hearing. There is rent to retain of $581.12, court costs of $164.53, for a total of $745.65 for him to pay or vacate by April 11th, 2022, and this is for possession only.
Thank you. Based on the defendant's failure to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $581.12, $164.53 in court costs for a total of $745.65. Plaintiff's office to submit that default judgment. Anything else in this matter, ma'am?
No, Your Honor.
This is 220737 LT. This is West Village Estates versus Ryan Fox and Roy Fox Jr.
Jenny Scheid on behalf of the plaintiff.
This matter was scheduled at 9 o'clock this morning for a second hearing in this matter. Defendants have failed to appear as of 9:26, ma'am. How do you wish to proceed?
We're requesting a default judgment for the defendants failing to appear at today's hearing. There is rent to retain of $1,337.23, court costs of $199.06, bringing the total to $1,536.29 for them to pay or vacate by April 11th, 2022, and this is for possession only.
Defendants having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $1,337.23, court cost of $199.06, for a total of $1,536.29. Plaintiff's office to submit that default judgment. Anything else in this matter, ma'am?
No, Your Honor.
Ms. Hall's audio is not connected. This is 220872 LT. This is Parkwood Manor versus Shakari Soros.
Good morning, Richard Herman on behalf of Parkwood Manor.
Today is the day and time set for the second hearing in this matter. The first hearing was on March 23rd, 2022, which time the defendant failed to appear. Notice was sent to the defendant to appear in person this morning. Shakari Soros. Matter was scheduled for 9 o'clock. It's now 9:28 by the court's clock. Defendant has failed to appear. Mr. Herman, how do you wish to proceed?
Judge, based on the fact that the defendant has not appeared either times that asked for a default judgment, rent in this matter to retain is $45.64 even, $4,564 with $154 in court costs. So the total redemptive amount is $4,718 with a writ to issue if it's not paid on or before 4/11.
Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $4,564, court cost of $154 for a total of $4,718. Writ date of April 11th, plaintiff's office to submit that default judgment. Anything else in this matter, Mr. Herman?
Nope, thank you.
This is 220873 LT Parkwood Manor versus Algernae King.
Richard Herman, plaintiff.
Today is the day and time set for the second hearing in this matter. The parties both appeared at the original hearing on March the 23rd. Algernae King. No one's responding to that. The matter was scheduled at 9 o'clock. It is now 9:29 a.m. by the court's clock. Defendant having failed to appear. Mr. Herman, how are we proceeding?
Based on defendant's non-appearance, I would request a default judgment. Rent to retain possession is $4,390. It's $4,390 with $154 in court costs totaling $4,544 even. Writ to issue if it's not paid on or before April 11.
Defendant having failed to appear as noticed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $4,390, $154 in cost for a total of $4,544. Writ date of April 11th, plaintiff's office to submit that default judgment. Anything else in this matter, Mr. Herman?
No, thank you.
This is 220910 LT Metro Commons versus Aaron Price.
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. First hearing was on March 23rd, 2022, at which time the defendant failed to appear. The court clerk sent notice to the defendant to appear in person this morning at 9 a.m. It is now 9:31 a.m. by the court's clock. Defendant having failed to appear, ma'am, how are we proceeding this morning?
We're requesting a default judgment entered against the defendant for failing to appear at today's hearing. There is rent to retain of $3,500.51. Court cost of $164.53 for a total of $3,665.04 for them to pay or vacate by April 11th, 2022 for possession only.
Defendant having failed to appear as noticed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $3,500.51. Court cost of $164.53 for a total of $3,665.04. Writ date of April 11th. Plaintiff's office to submit that default judgment. Anything else in this matter, ma'am?
No, Your Honor.
Thank you. Ms. Hall, are you able to hear us now?
I am.
This is 220932 LT. This is Rawsonville Woods versus Loretta Wright.
Yes.
Your Honor, if I may,
Yes, please.
but for the record, Attorney Ian Morton of Palace Law on behalf of Rawsonville. Your Honor, this is a non-payment of rent case. Ms. Wright, from our understanding, has passed away. Ms. Hall is the daughter of Ms. Wright. Ms. Hall is making statements that she believes that her mother had an ownership interest and or owns the mobile home, which my client disagrees with. Ms. Hall has been in communication with legal aid, although they have not been formally retained. But she provided documentation earlier this week. At this time, Your Honor, I'd have two proposals, but I'd look to the court. And I spoke to Ms. Hall about these. One, I propose that this matter be set for a non-jury trial date in 30 days, and in 2 weeks, we exchange documentation, so I know what I'm gonna possibly see. If not, if the court wants to do a brief adjournment to allow Ms. Hall the opportunity to be able to push on legal aid to make sure that if they're gonna represent her, that they're gonna need to get involved immediately. So I look to the court on how they want to proceed.
Ms. Hall,
Yes,
how do you wish to proceed this morning?
I wish to get into this formal trial and try to get the situation taken care of. I really do. I've been dealing with it for a long time.
So Mr. Morton, are we adding Ms. Hall as a defendant?
No, not formally, Your Honor. My intent is, once
Okay.
I actually see the documentation, so I know what I'm kind of getting into, was it a little bit more? I may end up dismissing Ms. Wright as she has passed away and then just move it to all occupants. But at this moment, I don't want to formally add Ms. Hall other than, and I'm hoping she's going to have documentation about being a representative of Ms. Wright. But again, I'm looking for documentation at this moment before I kind of even know which way I want to go.
Okay.
So what we'll say, Ms. Hall, is, did you receive, you have Mr. Morton's contact information, his address, phone number, et cetera?
I have Matthew Pallets, Livernois, which Ian is in this same,
Yes, that is
Right.
correct, Ms. Hall,
Correct.
yes.
okay.
So
Yes,
what we'll
I
do,
have that.
Ms. Hall, we'll set a deadline of April the 14th, 2022 for the parties to exchange documents. That means that whatever Mr. Morton has that he'll rely on at trial will be sent to you, and you will send him whatever you have. The court will set trial in this matter on May the 3rd, 2022 at 11 a.m. The civil department will send notice to the addresses that are on file in this matter.
Thank you, Your Honor.
Anything else, Mr. Morton?
No, Your Honor, just to make sure that Ms. Hall understands that, so yeah, with the exchange of documents, so you need to be able to mail those to my office, so I have those, so I have the opportunity to be able to look at those. I'm gonna do the same thing. Actually, and the court did bring up one good matter. Is it okay for me to mail things to the Brookview Drive address, ma'am?
Yes,
Okay, then that's where I'll send everything. Thank you.
thank you.
Anything else, Ms. Hall?
Nope, that's it, Your Honor.
I'll see you on May 3rd, ma'am. Have a good afternoon.
You as well. Thank you.
Thank you. This is 220915 LT. This is Metro Commons versus Barbara Kozlowskis.
Morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. The first hearing was March 23rd, 2022, which time the defendant failed to appear. Court clerk sent notice for the defendant to appear this morning at 9 o'clock. It's now 9:36 a.m. by the court's clock. Barbara Kozlowskis is not responding. Ma'am, how are we proceeding this morning?
We request a default judgment be entered against the defendant for failing to appear at today's hearing. There is rent to retain of $1,275.17. Court costs of $164.53 for a total of $1,439.70 for them to pay or vacate by April 11th, 2022. And this is for possession only.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,275.17, $164.53 in court costs for a total of $1,439.70. Plaintiff's office to submit default judgment. Anything else in this matter?
No, Your Honor.
Mr. Herman, I'm not sure why you're sharing screen, but I'm going to stop it for a second.
Yeah, there you go. Thank you so much.
This is 220924 LT. This is Southport Apartments versus Michelle Fitzgerald.
Richard Herman, plaintiff.
Mr. Herman, today is the day and time set for the second hearing in this matter. First hearing was on March 23rd, 2022, at which time the defendant failed to appear. Court clerks would have sent notice for them to appear in person this
All right,
morning.
thank you.
Michelle Fitzgerald, having failed to appear, matter scheduled at 9 o'clock, is now 9:37 by the court's clock. How are we proceeding, sir?
Judge, based on defendant's non-appearance, I would move for default judgment. Rent to retain is $3,802. $99 in court costs. So the total redemptive amount is $3,901 even. Writ to issue if it's not paid on or before 4/11.
Based on the defendant's failure to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $3,802, $99 in court costs for a total of $3,901. Plaintiff's office to submit that default judgment. Anything else in this matter, sir?
No, Judge, that's it. And I do believe that's all for me. I did have another one filed that is dismissed, which was 0926. Hopefully you got that dismissal.
The court has already signed it. Should already be back downstairs. Have a good day, Mr. Herman.
Thanks, Judge. You as well. Appreciate it.
Thank you. This is 220952 LT. This is Maple Leaf Gardens versus Melvin Bain and Brenda Bain.
Jenny Chine on behalf of the plaintiff.
Today is the day and time set for the second hearing in this matter. Defendants failed to appear at the first hearing on March 23rd, 2022, at which after that, the court clerks mailed notice to appear this morning at 9 a.m. Melvin Bain or Brenda Bain. Matter was scheduled at 9 o'clock. It's now 9:39 a.m. by the court's clock. Defendants having failed to appear, ma'am, how are we proceeding? You're muted. Ms. Scheid.
Sorry, Your
We've been doing
Honor.
this for 2 years now.
I've been only doing this for a year though, Your Honor, but your point is taken. My apologies.
It's fine. It made me look up. I was like, what happened here? Rent to retain, ma'am?
Rent to retain is $287.32. Court costs of $199.06 for a total of $486.38 for them to pay or vacate by April 11th, 2022, possession only.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendants with rent to retain of $287.32, $199.06 in court costs for a total of $486.38. Plaintiff's office to submit that default judgment. Anything else in this matter, ma'am?
No, Your Honor. Thank you.
Thank you. Is that your last one?
I believe I have one more left for Metro Commons, Bailey Allgood, 220911.
Mr. Allgood came on this morning and there's a Sarah stay in that file.
Oh,
He was
okay.
here at like 8:40 this morning. I didn't get the Sarah number because it was showing on our ROA as being Sarah stay.
Okay, I will make that note. Thank you, Your Honor. I think that does now conclude everything.
Thank you, ma'am. Have a good
Thank you.
day.
Have a wonderful day.
This is 220935 LT, Rawsonville Woods versus Michelle Bacardo. Michelle Bacardo. Mr. Morton, this is the second hearing in this matter. First hearing was March 23rd, 2022, which time the defendant failed to appear. Based on that defendant's failure to appear, the court clerks did send notice for them to appear this morning at 9 o'clock. It's now 9:41 a.m. by the court's clock. No one is responding to the name Michelle Bacardo. How do you wish to proceed, sir?
Your Honor, at this time, we would ask a default judgment for possession be entered. Rents retained are $1,970.12. Court costs of $164 for a total of $2,134.12, Your Honor.
Thank you. Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,970.12, $164 in court costs for a total of $2,134.12. Plaintiff's office to submit that default judgment. Anything else in this matter, sir?
No, Your Honor.
This is 220940 LT, Rawsonville Woods versus Jennifer Johnson. Today is the day and time set for the second hearing in this matter. First hearing was March 23rd, 2022, which time the defendant failed to appear. Based on the defendant's failure to appear, court clerk sent notice to the defendant to appear in person this morning. Jennifer Johnson. The matter was scheduled at 9 o'clock. It's now 9:42 a.m. by the court's clock. Defendant having failed to appear, sir, how do you wish to proceed?
Your Honor, at this time, we would ask a default judgment for possession be entered. Rents retained are $2,202.21. Court costs of $164 for a total of $2,366.21. Thank you.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,202.21. $164 in court costs for a total of $2,366.21. Plaintiff's office to submit that default judgment. Anything else in this matter, sir?
No, Your Honor.
This is 220947 LT Rawsonville Woods versus Brandon Hardy and Dezane Sudeth, Sudduth. Today is the day and time set for the second hearing in this matter. First hearing was on March 23rd, 2022, at which time the defendants failed to appear. Court clerk sent notice for the defendants to appear this morning at 9 o'clock. It's now 9:44 a.m. by the court's clock. Neither defendant have appeared. Mr. Morton, how are we proceeding in this matter?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $3,216.76. Court costs of $198, total $3,414.76.
Defendants having failed to appear by 9:44 a.m., default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $3,216.76, $198 in court costs for a total of $3,414.76. Plaintiff's office to submit the default judgment. Anything else in this matter, sir?
No, Your Honor.
I believe that concludes your docket, Mr. Morton.
That does, Your Honor, and add a little excitement for some future hearings then too.
Have a good day, sir.
Thank you, Your Honor.
This is 220830 LT. This is James C. Young Jr. versus Sierra Young.
Yes, Your Honor.
Ms. Young, are you able to activate your video for me, please?
Yes.
Thank you. Mr. Young, could you turn your audio on for me, please, sir?
No.
Could you state your name for me, sir?
Yes, this is James C. Young Jr.
Thank you. I saved this file for last because it seems to be a bit of a contested termination hearing. Is that accurate, Mr. Young?
Yes.
Okay. Ms. Young, have you filed an answer or formal response to the complaint in this matter?
No.
No, ma'am, we have not. We were not aware we had to do such.
I'm sorry, sir, your name is?
I'm Khalil Whetstone Sumter. I'm her boyfriend. I'm also an occupant and listed in the case or the original notice that we received.
Your name is on the original notice?
Yes, ma'am. Listed
I
as all.
don't see it. Okay,
Is
but
this-
I'm not gonna call you an occupant, so what I'm gonna have you do is spell your name for me, please.
Yes, ma'am. It is KALEEL. Last name Whetstone. That's WHETSTONE.
Thank you, Mr. Whetstone. Hold on one second. There's someone. Mr. Young, are you ready to proceed with hearing on this matter this morning?
Yeah.
Ms. Young, are you ready to proceed with the hearing on this matter this morning?
Yes.
Mr. Young, you have all necessary documents and witnesses with you this morning?
Yes.
Ms. Young and Mr. Whetstone, you have all necessary documents and witnesses with you this morning?
We have all documents that we have received. Yes.
Mr. Hales? Jonathan? For everyone that's giving testimony this morning, please raise your right hand. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes,
Thank you.
Your Honor.
Put your hands down. Ms. Young and Mr. Whetstone, did you receive a notice to quit from Mr. James Young Jr. on or about January 10th, 2022?
Yes,
And that notice indicated that you were to move from the property by February 10th, 2022?
yes, Your Honor.
Mr. Whetstone?
Yes, ma'am. I'm sorry. I was
And you
receiving.
both, and you both remain at the property right now?
Yes, ma'am.
And you received a copy of the summons and complaint to recover possession of the property filed by Mr. Young?
Yes, ma'am.
Mr. Young, this is your case. How do you wish to proceed, sir?
I would like to retain my property back ASAP. This is well, let me just please state, this is a property that was inherited because my father passed away of December 2020. And at the time, Sierra's mom was living there along with Sierra. Her mom has since then passed away, and now Sierra is claiming she has rights to this property, which she doesn't. So throughout last year, September, I tried to work with her. I gave her a lease. The lease went unresponse. And now here it is. I'm paying all the taxes. I'm paying they had the grass cut. I'm paying maintenance out of my pocket, along with my father has about $47,000 in bills. So me and
I'm
my
sorry,
other
Mr. Young,
yes,
did you say your father has $47,000 in bills?
yes.
Okay,
So what I'm trying to do here is sell the property. Yes, Sierra is an heir due to her mother, and it'll be divided up amongst all five of us. It's 5 heirs, so she has to move so I can get a realtor in there and sell the property.
Your Honor, may I speak, please?
hold on one second. Anything else, Mr. Young?
Also, she's been living there for 14 months, rent free. No rent at all from Sierra. That's all.
Mr. Hales, Jonathan Hales.
Yes, this is his sister sitting in for Jonathan Hales.
Ma'am, you can't sit in for someone else unless you're an attorney, number one. Number two, that case is not being heard this morning. There is a stay in place based on the application for emergency rental assistance.
Okay, thank you.
Have a good day.
You too.
Mr. Whetstone.
Yes. Okay. So I'm sorry, Your Honor. On March 14th, we received
I'm
notice
sorry,
from.
Mr. Whetstone, your video is sideways. I'm not sure.
I'm sorry. It's how the camera was being held. Is this better?
Thank you. That's better
Okay,
for me. Thank you so much.
So on March 14th, we received notification that things were going through probate, that Sierra was a qualified trust beneficiary. We're not simply just trying to squat at this property rent-free. All bills are current. Everything is being paid. Maintenance, as far as maintenance goes on the property, I believe Mr. Young has only had to cut the grass once. We're not just living here rent-free and just trying to get us living free off of his dime. We are taking care of things as we should. And as a qualified trust beneficiary and the heir of her mother, we're not exactly sure exactly what she is entitled to, but as far as legal counsel goes, we were advised not to simply vacate the property until everything went through probate, as it is going through now. And now we're in court now to speak with you today, and we're not just trying to live here. That's not what's happening here.
Your Honor, may I add?
I'm sorry, Mr. Young, hold on one second.
Okay.
The court did receive a copy of the living trust and the death certificates, and I am so sorry for the loss of both Mr. Young Sr. and of your mother. And I heard you say that things were filed with the probate court. So are you saying, Mr. Westone, that this property has not been transferred to Mr. Young Jr.?
Nothing that
Challenging his,
out of, because at this point in time, we are not speaking with one another. The family is estranged, and everything that is going through as far as procedures go are handled outside of this home and outside of our knowledge. Aside from the proceedings that we received as far as vacating the property. That's the only notice of anything that's been happening that we have received, to simply leave.
Mr. Young, I stopped you from interrupting Mr. Westone. What was it that you wanted to add, sir?
It's a couple things. Some of the stuff wasn't accurate. I have a lawn cutting business for 5 acres of last year for $2,500. So this ain't no city lot. It's 5 acres that I'm paying out of my pocket. I had a property cut. Now, second of all, I am the executive of the state and the executive of this trust. My lawyer has sent them a copy of both. So what the young fellow doesn't know is the property does not have to come out of probate for me to sell. I can sell while in probate, but it goes into the probate account. I can't touch it until it comes out of probate, and she can't touch it until it comes out of probate. So once again, when it comes out of probate, all 4 of my siblings, along with my niece, will receive their portion of that property.
Mr. Young, is the issue the sale of the property or Ms. Young and Mr. Whetstone not paying rent? What's the real issue?
The real issue is my father has $47,000 of past due debt that I'm paying out of my pocket. And me and my siblings, which is a total of 4 of us, Sierra makes 5.